Students, I am Professor Dr. Vidyapeeth, Director Faculty of Law and Governance from Jayoti Vidyapeeth Women's University, Jaipur. I hope you all are safe. So, today's our topic is will under Muslim law. The law of wills is contained in Part 6 of the Indian Succession Act 1925. All the provisions of Part 6 do not apply to Hindu, Buddhist, Sikh and Jain. In Muslim law, gratitudes, transfer of ownership may be made testamentary. Testamentary transfer is called transfer under a will. Will is a gratitude's transfer of ownership, but it takes effect only after the death of the transferor. Will signifies the last desire of a person regarding the distribution of his properties after his death. Accordingly, in all the systems of law, rules have been made to honor the last desires of a person regarding the devolution of his property. Devolution of property means transmission of property. In a will to the property passage on the person in whose favor the will is made. But a will is not governed by the provision of Transfer of Property Act 1882, where a person dies after making any will. The devolution of his properties after his death is to be governed by his personal law, that is, will by a Muslim law which governed by Muslim law. A will executed by a Muslim is called wasiyat. In respect of wills, it is significant to note that it actually modifies or sometimes negatives the distribution of property of a deceased under the law of inheritance under a will. The properties of the deceased devolve only upon the person of his choice. It may be objected that a will made by a deceased Muslim may amount modification in the law of inheritance, which is based on the rules laid down in Quran. A person must be mentally alert when he or she makes and signs a will. Age or physical condition is not a sign of incompetency. A person should also be free from undue influence, persuasion, or force while making the will. The law only requires that the two witnesses, who must not be related to you by blood or marriage, to watch you sign and date the will, and that they know you have said it is your will. To prove a will, it has to be shown that the will is the legal declaration of testator's intention. The testator was of sound disposing mind during execution. The testator executed it of his own free will. Two essential characteristics of a will. Number one, it takes effect after the death of the testator, and it is revocable during the lifetime of the testator. According to Jayoti, will means a legal declaration of the intentions of a Muslim with respect to his property, which he desires to be carried into effect after his death. According to Bailey, will is a device for conferring a right of property in a specific thing or in a profit or advantage in the manner of a gratuity postponed till after the death of the testator. The wasiyat can be made orally and no writing is required under law. When this is the case, the beneficiary is required to prove beyond doubt the intention to make the will by the testator and the terms of the will, and to prove the same with utmost precision. If the will is written, the writing need not be described as a will. but the intention should be decisive, and it need not be formally signed by the testator. And further, it is not required to be attested, or registered. All the properties that belong to the testator are transferable, can be disposed of by the help of a will. Condition for a valid will. Two conditions is necessary, essential conditions for a valid will. Number one, write down the legislator and the legatee must be competent. दोनों का competent होना जरूरी है. Competency of the legislator who can make will. The person who makes a will is called legislator or legislator. The legislator must be the capacity to make a will and fulfill the following conditions: Muslim soundness of mind, age of majority, suicide attempt by legislator. The legislator must be a Muslim at the time of making the will. Only that will is governed by Muslim personal law. In which the legislator was a Muslim at the time of its execution. If a will has been executed by a Muslim who can cease to be a Muslim at the time of his death, the will is valid under Muslim law. All the time of execution of a will, the testator must be a sound mind. A will by an insane person is void. The testator must be adult. He must have attained the age of majority at the time of execution of the will. The age of majority is 15 years, but it is not applicable to the wills in India. The testator must be 18 or 21 years, as the case may be at the time of execution of the will. A will executed by a minor's void. Under Siala, a will made after the testator who was injured by his own action or tried to commit suicide, such a will is declared as invalid. In Mazhar Hussain versus Bodha B, it was held. इस केस के अंदर क्या कहा गया कि a will of suicide is valid when made in contemplation of taking poison, but before poison was actually taken, onus of providing that the will was written afterwards rest on party in bargain with. Is it clear? The topic is complete. If you have any doubt, you can write down the question. It's very important for examination purpose. Explain the conditions for a valid will under Muslim law with decided case law. So, Thank you for listening me.